You too, Miss Tone. Back with another one for you. So this one here is a continuation of Creditors and Their Bonds. This is what do you call it? This is a continuation of Creditors and Their Bonds. This is number 10. So what do we got here? Let's get right into this shit. So here we have that you have. So now what you have done on the private side has not appeared on the public side yet. Remember rule number 1. If you do not let the public know what you are doing on the private side, it will appear as if you are ignoring the presentment that will result in a default judgment due to your dishonor of the state's presentment. Right? So let them know, bro, look, if you're trying to discharge that motherfucker, the case or whatever, let them know. You know what I'm saying? Don't surprise them in the fucking middle of a goddamn fucking proceeding in front of everybody and shit, because it's not a good look. The whole point is to not fucking alert the public like I'm doing here with this fucking channel. You don't want to do that. I want to do that though, so I do that. How else are you gonna fucking know unless I fucking do this shit? So look, you know what I'm saying? So if you're gonna start working on the private side to discharge any of these fucking commercial claims, which all of them are, because they're all corporations, let them know. You know what I mean? If you're gonna check them, if you're gonna put these niggas in checkmate in the middle of court, let them know beforehand so you can be the only person in the courtroom. They don't they don't like getting checked in front of all their fucking customers. You know what I'm saying? So get a certified copy of the judge's oath of office and accept it for value. Right? Stamp that bitch, boom, accept it for value. That is the evidence of the man's contract with you, the people, on the private side. You want him to take judicial notice of his contract with you. Filing it with a copy of oath with the clerk's office will not accomplish that end. But it will give them notice that you expect the terms of the contract to be followed. So you will have to enter the certified copy of his oath into the evidence file in open court to actually have it make any difference. So get a certified copy of the judge's bond and accept it for value. That is evidence of the limited liability that the judge, the person, has on the public when dealing with citizens and residents that are either owned or controlled by the corporations. It does not limit the private liability that the man has with dealing with the people, you, on the private side, since there is no money to pay for you if you are damaged by the actions of the judge. You will have to be satisfied with the possible payment of the straw man, John. But that is not the reason that you are bringing this bond into the issue. The reason is to notify risk management, if necessary, that you have been damaged by one of its insured persons. So this is not the bond for the man, but the bond for the judge on the public side. So this man is doing business as a judge for the public from time to time, but he can also come under the private rules of equity, which is broadly defined as what is right. It is the right for this man to be recognized as a creditor, but only if you perform like a creditor. Avoid going into dishonor. If you dishonor anyone, you will fit the profile of a debtor, straw man, and he can ignore the private side. So give notice of your acceptance by private mailing to the man or woman by doing business as a judge, not for filing to the clerk. Mark the envelope private. He have a notary mail it by certified mail. Give you a certificate of service, right? The return address is the notary's address. The components of the letter are this. You have accepted the presentment for value and returned it. You have exchanged your exemption for the discharge of the charge. You want settlement and closure. You are requesting an appearance bond at no cost to you. You are not disputing the... Mind you, I have some appearance bonds and shit like that too, affidavits if you guys need them. You don't need to be bonded by these fucking assholes. You can set your own bond based on the value of your existing bonds that you already have filed with the Secretary of State if you did your UCC and all that, right? So that's why it's a good reason to get all that shit done. Also, it's a good reason to get your estoppels in there. I offer that package as well, so you can get your contracts already in place before you run into any problems. That's the best thing to do. Okay, so you are not disputing the facts. The parties have reached an agreement. There is no controversy. You have accepted the judge's oath and bond for value. Include a copy of the notary's certificate of non-response from your administrative process to confirm there is no controversy. File a notice of acceptance on the public side. This will let the public know that you are doing something on the private side to settle the account. If you do not give the public notice, it will be assumed that you are standing mute. That is a dishonor. it results in a default judgment or summary judgment, what would this say? It is your intent to settle and close the accounting immediately. You have accepted and returned the presentment. You have exchanged your exemption for the discharge of the charges. You are requesting an appearance bond at no cost to you. You do not dispute the facts. You will enter a plea for the defendant. You want to be advised of the details of the hearing to receive the bond and enter a plea. You are bringing the argument of the parties and the judge's oath and their bond into the case. Right? So you want that shit filed onto the case, so there is no question as to what your intention is if they go ahead and harm you or injure you or your person in any way. Right? So they can't be fucking surprised when you go ahead and file your claim against their bond because you already put them on notice. Public defender. If there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant. Rule number 1, the public and private side can never be mixed. They can't do it, you can't do it. Don't ever mix them. So be careful that you don't either. If the defendant has a public defender, that is good. When the prosecutor signs the complaint, verifying it, and his signature is notarized, he is taking on the liability that may follow in the event if it is discovered that the complaint is not valid. He is taking a chance because at that point, he is the only attorney on record. He has filed a form of notice of appearing by filing the complaint, filing with the grand jury indictment. He technically represents the defendant until someone takes his place. He is counting on someone appearing in the case to defend against his complaint. If that doesn't happen, he is the responsible party and liable for all the costs, paid, and complaint or associated with the statute violation. If that does happen, then he is off the hook. Almost 100% of the time, that is what ends up happening. He is pretty safe taking the chance. Usually the straw man named on the complaint gets a good attorney to defend him. That means that defense attorney has taken on the liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney on record for the defense, he is on the hook. So now he has to get someone to take his place. That likely taker on the position is the straw man in the complaint indicted or traffic ticket. The straw man can talk, so the straw man can't talk, so someone has to represent it. Usually that is you because you have a point to make or a lesson to teach or testimony that will prove your case. That's the wrong choice. And it is a wrong choice. When you go there and you're speaking as the fucking defendant, they already know you fucked up. When you go there as the authorized representative and speak on for the fucking defendant in the third person, that's when they know that you probably know what you're doing, but probably still don't, right? So this is almost always the losing proposition. Really good off-point paperwork has been put into court for decades with a very low success rate. The only way to win is to let the state win. I love win-win situations. How can you win and the state win at the same time? If you accept the presentment and return the presentment and exchange your exemption for the discharge of the charges, the state gets the credit from your exemption and you get the discharge when you bond the case. Well, that sounds easy, right? If the defense attorney can get you to act as the trustee for the straw man trust name on the complaint, defense attorney is off the hook too. It is just a series of passing the buck, a hot potato game. The one who ends up with it has to pay the bill. The prosecuting attorney starts with it, it goes to the defense attorney, he files a notice of appearance, and then on to the straw man. If you volunteer to defend, argue, testify, or join the action in any way, it eventually ends up on your lap. You are stuck with the public liability unless you accept and discharge it from the private side. Hot potato game. Prosecuting attorney, defense attorney, straw man, you. Right? So you don't want to sit here and argue with these fucking people, especially not as the fucking defendant. You can go in there in a special fucking appearance and talk shit to them all you want, but you're not going in there as a fucking defendant. That's how you lose. Because the fucking defendant's a piece of paper. Do you really want to be a piece of you want to be a piece of paper? So get a copy of the court order appointing the attorney to accept it for value. This only if the judge appoints a public defender. Do not dishonor the court by refusing this privilege. The privilege is for the straw man, not for you. You can accept his services offered by the court and instruct him on how he will handle the case. You can do this because you are the creditor through your acceptance. You are in honor is the point of the court. The prosecuting attorney, the clerk, and the appointed defense attorney are also in honor. Prepare a letter of instructions to be mailed with the appointed defense attorney. This letter to the attorney is your contract with him. If you do not establish the terms of your contract with him, the presumption will be that he is a defense attorney and that he is defending the defendant as an officer of the court. Get a certified copy of the letter to the lawyer from the notary before it is mailed to the lawyer. If time is crucial, fax it to the lawyer with a notation that it is also being mailed by certified mail. Have the notary mail it. Have the notary mail it be certified mail RRR. So if you give a certificate of service, what should this letter say? You are claiming an interest in the subject matter of this case. Intervening your property rights may not be protected by the existing properties. You are accepting the public defender appointment offer and returning it. You are requesting that the public defender put his bar card away during this case. You are requesting that the public defender act as your counsel instead of acting as an attorney. There is no controversy over the facts. He cannot start or join the argument. He is not authorized to defend the defendant. You are asking that he read the entire letter into the court in open court and file it with the clerk. You already have an agreement of the parties. Copy of a certificate is attached. You are asking him to check the clerk's file for a bond and bond the charges. You are not disputing the facts. You want the prosecuting attorney to write the check to close the account. You will accept the prosecuting attorney's bond for the bond of the charges. You will start bankruptcy if necessary to locate your remedy. Right, and Title 15 is also great. You know what I'm saying? I mean, I personally have not done that, but Title 15 is what the fuck should stop the collection right in its tracks, because it's an unfair debt collection practice that they're executing here with all these actions in general. So you will start bankruptcy if necessary to locate your remedy. You want settlement and closure. You may require the defense attorney to file a notice of appearance in the case. Check the clerk's file for a bond. There has to be a bond in every case in the event the complaint of a fraudulent claim is made. The presumption is that the prosecuting attorney's bar number is bond in the case, but there is no written evidence of a bond in the file. If there is no written bond, then you can bond the case. The presumed attorney's bond is superseded by a written and signed bond. Get a certified copy of the docket sheet at the clerk of court, which will document that there is no bond on the case. A predated bond might show up in the file later and minimize the effect of your bond. You can bond the case. The bond falls into the category of a replevin bond. It is not a replevin bond because they were used in common law before the court system's law and equity were integrated into one. So now it has to be a bond that is in the nature of a replevin bond that is used the same way that a replevin bond was used. And so the replevin bond is basically a bond that is used in order to close a matter, and basically a surety bond. So a surety bond to close the matter of the whole situation at hand, to close the fucking accounts. And so that's something that you would use in order to gain remedy in a situation like this, where nobody wants to fucking smoke, but they want to close the fucking thing, right? And no parties have to fucking accept liability for any of their actions. So it is a game of chess. Stop playing fucking checkers with these goddamn assholes. That's what I got for you for now. Until we meet again.